Good morning, this is your Kelso Report for Thursday, January 19th. I'm your host, Clark Kelso. We've got 4 California Court of Appeal decisions today. We begin with water law. When a court enters a legal damages judgment, and that judgment becomes final, the case is pretty much over. You don't really go back and ask the court to change the numbers once the case is final and done with. But the rules are quite a bit different when it comes to equitable orders, and a good example is the 2nd District's decision in Water Replenishment District of Southern California versus City of Cerritos, where the court faced a request to modify a 1991 court order, which was itself based on a 1965 consent judgment, declaring and establishing water rights in the Central Basin, which provides a source of water for many cities, water companies, school districts, landowners, and others in Southern California. The Superior Court held that it lacked jurisdiction to modify the order, but the 2nd District reversed, noting that both orders had expressly reserved continuing jurisdiction to review and change permissible levels of extractions from the Central Basin. And that reservation of jurisdiction still existed and gave the trial court continuing jurisdiction. So the appellate court remanded so the trial court could now consider the motion on its merits. Next, family law in a divorce case. Now, in this case, 2 members of the 1% Club, each of whose net worth was in the tens of millions, married each other in April 2001 after signing a prenuptial agreement which, among other things, contained a waiver of the provisions of Family Code Section 1615 that otherwise would have required disclosure of each spouse's financial condition. Both parties were represented by counsel at that time, and both signed it. Well, after they divorced in 2008, the wife sought to avoid the prenup by claiming that her husband had fraudulently misrepresented his personal worth at the time of the marriage. In the 2nd District's opinion in In Re Marriage of Hill and Dittmer, the appellate court affirmed the trial court's denial of the wife's request for additional discovery of the husband's wealth, and upheld the prenup's waiver of the disclosure requirement. The court's reasoning is summed up nicely in the final sentence of the opinion as follows, quote, "Judicial erasure of a competent adult signature on an agreement does not serve the purpose of the law of contracts to protect the reasonable expectations of the parties." Close quote. In short, when you got tens of millions of dollars and you got a lawyer and you sign a prenup, you're stuck with it. And next, a case involving the law of preclusion. Now, as I had noted in yesterday's Kelso Report, the policy behind the rules of claim and issue preclusion is that a litigant should have one and only one opportunity to litigate. There has to come an end to litigation. Now, there are 2 parts to that test. A litigant does not get more than one opportunity to litigate. At the same time, a litigant must ordinarily be given that first opportunity. Well, today we see the 2nd District in Bridgeford versus Pacific Health struggle with the question of how to apply issue preclusion and collateral estoppel in the context of a class action brought by a putative member of a class that, in prior litigation, was denied certification. The question was whether the rejection of the class certification in the first litigation precluded the plaintiff, who was a putative member of the never certified class, from taking another run at the defendant. The issue was essentially the same in both actions, whether to certify the proposed class. But the plaintiff never had that first shot at the issue, even though the defendant had already litigated it. The 2nd District held, consistent with the rules set forth in the United States Supreme Court's recent decision this last term in Smith versus Bayer, that a member of a putative class that is never certified cannot be bound by collateral estoppel, since that person was not a party to the prior litigation. Only if the class was certified in the first case can principles of preclusion apply to class members. So, The appellate court vacated the trial court's order that had sustained the general demurrer on that ground and directed the trial court to enter a new order overruling the demurrer and letting the case go forward. Our last case involves consumer protection and the law of privacy. Now, just last year, the California Supreme Court held in Pineda v. Williams-Sonoma Stores that Section 1747.08 of the Civil Code bars a merchant from requesting and recording a consumer's zip code as part of a credit card transaction. In yesterday's decision in Alvarez v. Brookstone Company, the defendant tried to avoid Pineda by arguing that it should be applied prospectively only. The Fourth District rejected this attempt to avoid responsibility. The general rule, of course, is that common law decisions are given retrospective application. The theory, some would call it a legal fiction, is that a common law court simply declares what the law has always been. It does not actually change the law like a legislature. If there happens to be lower court opinions that have previously come to different conclusions, well, that simply reflects the reality that courts can make mistakes. The fact that lower courts can make mistakes does not warrant an exception to the general rule that court decisions ordinarily apply retrospectively. So, the appellate court reversed the trial court's decision that Pineda did not apply, and the court remanded for further proceedings. And that's it for today's Kelso Report. Have a great day in the law.